Hi everyone, welcome to this very special Law Week event on resolving residential tenancy disputes. I wish to acknowledge the people of the Kulin Nations on whose land we're gathered today and pay my respects to their elders past and present. My name's Genevieve Grant and I'm the Director of the Warren Centre for Civil Justice in the Faculty of Law at Monash University. The mission of the Warren Centre is shaping better civil justice access and outcomes through high quality and impactful research. And today we're very pleased to be collaborating with colleagues at the Victorian Civil and Administrative Tribunal to bring you this special webinar. Victorian Law Week is an annual week of community-based events to help Victorians identify their legal problems, to learn how the law works, and to get the right help to solve legal problems. And there's a huge range of events on this week in a program managed by the Victoria Law Foundation, and we're very grateful for their support. So in today's event, we'll be looking at the way residential tenancy issues are resolved in Victoria, and these continue to be one of the most common types of legal challenges facing Victorians, often resulting in stress, delays and expense. And in 2025, the Victorian Civil and Administrative Tribunal introduced Rental Dispute Resolution Victoria, RDRV, a new fast, fair and free way to resolve many tenancy disputes. And today we're joined by two speakers who'll be in conversation on this new service. So we're joined by, firstly, we have Mr. Warwick Mitchell, who's the Executive Director, Operations and Support Services at VCAT. Warwick is an experienced leader with more than 15 years expertise in policy development and legal services across Victoria and South Australia. And in his role at VCAT, he oversees the organisation's core operational functions, including registry, member support and hearing services, community access services, legal services and query support. He also exercises the day-to-day responsibilities of the Principal Registrar under delegation. So before joining VCAT, Warwick spent a decade with the Department of Justice and Regulation, where he held a range of senior roles in civil justice and civil law policy. So welcome, Warwick. We're also joined today by Jack Davis. Jack is a team manager with VCAT's Rental Dispute Resolution Victoria. And in this role, he oversees a team of resolution coordinators who are responsible for case managing disputes between rental providers and renters. Jack's passionate about the value of ADR and the RDRV model. His expertise includes guiding teams to help people to grow and realise their potential. And he has more than 10 years experience in customer service, leadership, complaints management, coaching, stakeholder engagement and service improvement in both the private and public sectors. So welcome, Warwick and Jack. We might start with setting the scene a bit. So perhaps, if possible, Warwick, we might start with you. I mean, could you tell us a bit about what the resolution of residential tenancy disputes look like before RDRV, you know, the sort of volume of disputes, the typical process, and what the experience was like for people involved?
Sure. So I guess the first thing to say about residential tenancy disputes for VCAT is that it's by far and away the largest jurisdiction for VCAT. So I think typically we've had between sort of 40 and 50,000 applications made annually that are residential tenancies disputes. And RDRV covers roughly about half of those. So there's still a continuing number of applications that are not covered by RDRV. But the experience really for people coming in to the system and having their dispute resolved at VCAT depended to a fairly significant extent on who they were. So obviously the most common users of the residential tenancies jurisdiction are either property managers, so people who are managing rental properties on behalf of landlords or rental providers, as they're called under the Act, and the renters themselves. So the property managers, as you'd expect, are often really quite familiar with how the VCAT process works, and often they get a lot of internal training on how to run VCAT matters from within their respective firms. And they also will be very experienced and practiced with themselves after a period of time working in the industry. For renters, it's obviously a different story because they're coming with very little knowledge often, and they had, in the prior VCAT experience, probably fairly limited contact with anyone at VCAT before the matter would ultimately be brought to a hearing. So it's always been a sort of a high turnover, fairly fast jurisdiction. So matters would ideally be brought to a hearing within a few weeks. But often the experience is one of receiving notification that a matter's coming to VCAT, being asked to submit documents and other evidence that will be used in the hearing, usually by email, and then attending the hearing day after getting a notice of hearing on the day to attend. And then the VCAT member who would be presiding in the case would hear the evidence from both sides and then ultimately make an order. And so in the lead up to that hearing event, often, as I said, there probably wouldn't have been a great deal of contact that people would have had with a person at VCAT. Obviously, we always had a contact centre and people could ring, but it wasn't sort of the default channel by which people would be engaging with VCAT. And so everything really kind of followed that basic pattern of application being made, notice or service being provided to the respondent that the application had been made, and then a request for documents and evidence to support the hearing process, and then eventually the hearing being scheduled and then run with an order to follow. And most matters in residential tenancies follow that sort of basic pattern. We had, the context in which this was occurring was sort of after COVID. And so, the COVID was a significant disruption to services at VCAT and for many other government services. And the area that it perhaps affected most in all of VCAT was a subset of residential tenancies matters, and primarily claims for bond and compensation. So we had significant changes to the way the hearings were being run over COVID. So particularly whereas matters had previously almost always run in person, during COVID, the default became running them either via Zoom for a small number, but more commonly via teleconference. And as a result, the fewer matters were really running daily, and so there was a significant build-up of particularly those bond and compensation cases. We then had to deploy a specialist program to resolve that significant build-up of cases, which commenced in about 2023, and reduced that down to the normal level. And then we were sort of starting the process of RDRV post that point.
Right. No, that's really helpful context to hear. And I guess if we move forward those few years to June 2025, RDRV was announced as part of the housing statement that was launched then. And what was the kind of the broader policy case for the new model? What were the sort of objectives that were central to the design of the new approach?
Yeah, well, obviously, VCAT wasn't actually, we didn't draft the housing statement or not directly involved, but I think we obviously gained a fair bit of insight into what the policy environment was and the policy objectives were. And in addition to that, we had already commenced our own work, preliminary work around overhauling the model of handling residential tenancies disputes ourselves. And so there was a high degree of alignment between what was announced as part of the housing statement and the work we'd already commenced. We'd started this process or this program of work that was looking really deeply at what the experience of people coming to VCAT was to resolve residential tenancies disputes. And we did things like followed individual files from one beginning of the process to the end of the process to see how many times people had to engage and the number of different times people were asked for different pieces of information and things like that. We also rang quite a number of users who'd been through the process probably about 6 months prior and asked them about the further insights into their experience. Talked to our staff, talked to our members, and started to form a really good picture about what it is that people actually needed in the process, and started to redesign the process around those requirements. And so I guess, in terms of articulating some objectives, some of the principles that we started to articulate through that work were things like helping people to resolve disputes at the first opportunity. So recognising that there was an extent to which there was a high degree of uncertainty around what the dispute environment was like, what the law required, how it applied to people's individual circumstances, and so on. And what they really kind of needed was some help just in brokering discussions about how to resolve matters. We also did things like trying to take work away from users so that things weren't kind of getting stuck between us and the users, so that we would do things like create a single point of contact within the organisation for people to be able to work with and would know the history of their case. And we just developed sort of operating principles, things like every time we pick up a case, we'll try to move it forward rather than sort of picking it up and putting it down. If we're not adding value to the case, then we're not sort of contributing to its resolution. But clearly the sort of prevailing objective here was trying to reduce the amount of time people spend in dispute, reduce the amount of effort that's applied to resolving disputes that is disproportionate, arguably, to the requirements for resolving the dispute. And I suppose in particular, kind of delivering more kind of confidence and certainty around what as I say, the law is around what the options are for people to resolve their disputes, and in that way providing more stability in the overall environment. So I guess it's the kind of the broad goal for any dispute resolution service is to sort of deliver somewhat loftily, I guess, the ideas of social and economic stability through having a confident way of people coming to resolve their disputes.
Great. And I guess, thinking about that idea of the broader context for this work, I mean, are you able to tell us something about how RDRV fits in the broader landscape of dispute resolution reform, and what sort of distinguishes what's happening at RDRV from what you've seen elsewhere?
Yeah, it's an interesting question. I mean, I think there's it's not a unique model in some respects. Like I think we obviously it's probably unique to the extent to which it's been built as a separate service with its own kind of branding and identity in the community and so on. But the idea of a step before a formal hearing or a formal determinative outcome is not a new one. I think quite a number of models have already existed. Even in Victoria, we've had a long-standing model that the Consumer Affairs Victoria has for frontline dispute resolution for compliance issues, sort of as an adjunct to its contact centre. We also have work ourselves that we were directly involved in at VCAT. So during COVID, there was a preliminary step where people would go via a dispute resolution officer and get a form of either they would resolve their dispute or they'll get a kind of accreditation that it was unable to be resolved, and they could then come to VCAT. And similarly, we worked directly with groups like the Dispute Settlement Centre of Victoria to take some of our caseload and attempt to resolve it before it came to hearing during, again, that sort of the tail end of COVID. So these models do exist, and I think outside of Victoria, there's certainly other models in Queensland and New South Wales and so on. They're probably the main difference, I guess, from what I understand to be the most common models is the degree to which RDRV is quite integrated into VCAT, and it all sits under the VCAT umbrella, and that gives us a number of advantages really. So in particular, we can not reproduce a lot of work when matters don't resolve. So we can essentially move relatively seamlessly between the early resolution sort of stages that RDRV is working on to the hearing stages if the matter is unable to be resolved by RDRV. So people don't have to kind of resubmit application forms, for example, because they've already entered the VCAT process formally by making their RDRV application. And similarly, they don't necessarily need to reproduce all the content and the conversations and things that they've otherwise had. And we can usefully strip out some parts of the dispute themselves where people have already made some decisions about those in the lead up to a VCAT hearing, and then the matter can then come on before a member for determination of those parts of the dispute. that remain. So that kind of hybrid model, I don't think exists in quite the same way in Australia. I think there may be international models that are a little bit similar, particularly in Ireland, maybe in Canada as well, that have kind of a combination of different RT dispute measures in the one place, including some regulatory ones. But for Victoria, it's quite a new model, and probably the other really major distinguishing characteristic I think of RDRV has been the way we've gone about building the capability for dispute resolution within the particular staffing group that we're using for RDRV work. So whereas I think in a lot of other models, there's been specialist kind of mediation and conciliation capacity or capability that people have brought in. In our case, we have worked with our existing staff, and also we've recruited staff who have kind of a broad range of skills, but then given them specific training in mediation and accreditation for mediation, which has allowed us to kind of expand that pool. But it's also meant that we've had to really focus on building that capability as a core part of the work, because there's a really as a significant kind of art to being successful in a dispute resolution role, and the model really does depend on that capability. So we've had to invest considerably in that.
Yeah, those are really, really useful insights, both in terms of the sort of the workforce and capability side of things, but also what you were mentioning earlier about sort of reducing the administrative burden on participants in disputes, so they're not finding they have to, tell their story multiple times through different parts of the dispute process. And I wonder, Jack, if we might turn to you, would it be possible for you to walk us through what this process looks like in practice, from the moment someone submits an application through to resolution?
Yeah, of course. I think the process itself is probably a little bit determined by the actual application. So we do the repairs, excessive rent, and bond and compensation. So all have a slightly different structure in terms of maybe the timings and how we would look to progress those. But there's definitely some commonalities between that, and that the resolution coordinator from an application submitted through the portal, and then it would be picked up by a resolution coordinator who would do a lot of triage. So they would assess the application, talk to the parties, do a lot of the sort of almost the clerical things inside to make sure the legal application is aligned and everything is set up how it should be. But then the key part of what we do is a lot of fact finding and a lot of asking questions and understanding, because realistically, the parties are always the ones in the driver's seat of what we do, right? The way Warwick would have heard me use this example, that the way I explain it is that the parties and the applicant, they're the one in the driver's seat. We're the ones in the passenger seat with the map sort of letting them know the various options to go down. And so the more we learn about the sort of two parties involved in the application, the more we can determine what may be appropriate sort of dispute resolution for that. So from a application in general for, say, a bond and compensation matter, which is one of our more common applications, from picking that up to going through the initial sort of checks and the conversations and the start of the resolution, and sort of trying to resolve it at the earliest possible point, we're probably looking at around the 2-week mark. And then once it gets to that point, if we can reach a resolution, brilliant, we can sort of facilitate the resolution through orders or whatever the outcome may be. But then if it sort of is a situation where we can't resolve it or it's not appropriate to do so, and this can also happen up front in the process, we would start the process of getting it sorted for a hearing. So a resolution coordinator would almost sort of change a hat in a respect, and they don't focus so much on the early resolution, but it's case managing and helping parties prepare documents, gather everything, share it across the parties, and do what they need to do so that when a hearing does come about, we can make the most of the time and actually get an outcome at the end of that, at that sort of process. But like, for example, just as a contrast to that, repair applications, because of the legislative timeframes around how quickly they need to be dealt with, an urgent repair, for example, we want it to be within a hearing, I think within 3 to sort of 5 days from the application, within 3 days. That window for the early resolution is a lot smaller. So we would have those preliminary conversations, but with those applications, often RDRV's involvement is enough to actually expedite some action, to actually start seeing some results from the application. But while we do have sort of I'd say more sort of the structured process. It does vary a lot depending on the people that we're dealing with, because they very much dictate what the best course of action is or what the appropriate sort of next step should be.
So, yeah, I mean, given what you've said about the potential for variability there, I mean, I wonder if you could tell us a bit more about the role of the resolution coordinator in that process. I mean, what that role involves and how it's contributed to the sorts of outcomes that are being achieved.
Yeah, I think sort of what Warwick mentioned about, we have, a lot of various backgrounds, but a very strong commonality with our resolution coordinators is they're very driven on helping users and helping drive outcomes. But what that outcome can be can, again, as I was sort of saying before, depend on the people involved in the specific situations. But a resolution coordinator, as I was sort of saying, they wear two hats. It's case management and early resolution. So when, like, an early resolution, or when we're dealing with a matter, that can come in a few different forms. So day to day, you might do a mediation session, which is a structured, online or potentially in person meeting with all parties, with the resolution coordinator sort of shepherding and guiding the conversation. Sometimes that might not be appropriate if there's been sort of a degraded relationship between the parties, but still some commonality in terms of the issue. We might lean on what we call a facilitated discussion, which is sort of more of a shuttled mediation. So the resolution coordinator would be passing the information through. Sometimes a big part of it is just being able to sort of deal with the situation and determine that a member is actually the best person to speak to this instance if it is complicated. So a lot of what the resolution coordinator would do would be providing relevant information that's going to help the parties through the process. So, I think Warwick touched on that a lot of our applicants are initiated by rental providers and real estate agents. So a lot of the information around what we would give tenants, for example, is around sort of supporting them and how they can get the information to sort of make sure that they're feeling well informed and comfortable with what's going on. So a lot of it becomes sharing resources or providing bits and pieces of information and sort of guiding them to get what they need to feel comfortable with going through the steps. So yeah, a bit of variation through that, but that's sort of in a little bit of a nutshell, I guess.
Yeah, terrific. And I guess on that note of what it is that people can do, or the sorts of steps they might take to prepare for engaging with RDRV. I mean, are there particular matters that, from your experience, it would be useful for parties to address, or steps they might take to save time and improve their chances of a resolution once they get to RDRV?
I think broadly speaking, just an understanding of the process in terms of, so we can provide that as well. But there are a lot of good resources that parties can lean on. Like, for example, Tenants Victoria is one that we refer to people a lot. Consumer Affairs Victoria, in terms of information about how the process works and what you need to do to support your case. So resolution coordinators, we don't give legal advice, but we will provide information. But sometimes, providing the information, people, especially with the current state of things, people want support and help. So a lot of what we have to do is being able to provide that information and provide the additional steps on how they can get the clarity and additional support that they would sort of look at. So I think being informed is definitely a very big part of it. And I think that communication is a really, really big part of it as well. I think a lot of the matters that we deal with and a lot of matters that we resolve through mediation are purely through a sort of really degraded communication between a property manager and a tenant, very commonly. So a lot of what we do, it isn't sort of rocket science. It isn't, giving any sort of game-changing advice. It's just providing a platform for people to have that conversation and sort of shepherding that conversation for that. So if there is information or communication that can be done beforehand, a lot of the time it can be, we could probably even prevent going through this process as well. But sometimes that's also not necessary, or not sort of an option as well. So that's why we're here.
Yep, absolutely. And I wonder too, I mean, given what you've said about the fact that the sizable proportion of the applications are brought by the providers, and we know that tenancy disputes don't always start on a level playing field. What are the sort of the features of the design of RDRV that you think account for those sorts of power imbalances? I mean, the sort of the mechanisms that are available to address that.
Yeah, I think Warwick will be able to talk to a few of those. I mean, from a resolution coordinator point of view, a lot of we do is that informational side of things. So we've given a lot of training to support and identify people when there are power imbalances, or asking a lot of questions to try and not just take things at face value, but understand the meaning behind that to sort of determine what the best part of advice would be. But a lot of the resources like Tenants Victoria, Legal Aid, Consumer Affairs Victoria is being able to determine the appropriate thing for that. But that's from a resolution coordinator, where I could probably be able to touch more on the design side of things.
Yeah, it's a really big and important question, I think, Genevieve, because it's something we spend a lot of time discussing internally as well. And the we are mindful that we can't kind of control everything that informs the nature of that power imbalance. Like economic circumstances are a significant feature in that sense of vulnerability that people often have. So if the rental market's especially tight, then people are probably, arguably going to be more uncomfortable around, enforcing their rights and things like that. So we have to be quite sensitive to those things. What Jack spoke to about, the training for resolution coordinators, and in particular that ability to identify, vulnerability, imbalances, perceived bias, and so on. I think those things are, critical to the performance of the role, and helping to create that sense of, equality in the discussions. And as a couple of, sort of practical things, the fact that, as I mentioned, this is quite a hybrid model where we've got that degree of interwoven sort of relationship between RDRV and VCAT, means that we can make use of our members very effectively in that sense. So part of that is just, again, in the training space. So we've got, access to members to help resolution coordinators understand the law and how it applies in particular scenarios and so on. Both, at the sort of the general level in terms of training, but equally often on a sort of day-to-day basis, so people can ask specific questions about specific cases in certain contexts. And then we also have an arrangement whereby agreements that are made between parties will be signed off essentially in the form of a consent order, which is a VCAT consent order, which means it does go via a member for them to sign off. And that means that there's that sort of kind of a stop or a safeguard, rather, in relation to where a member might identify that there's perhaps some concern around whether or not a particular agreement is reflective of what the law requires in a given context, and so on, or any other type of concern. They can raise that as part of the sign-off process, and that is a useful way of leveling the playing field. But more generally, I think just the presence of the model in some ways provides, and that presence, particularly the resolution coordinator brokering discussion, does contribute quite a lot to that sort of sense of equality, in that people no longer feel quite as though they need to be able to represent their position. They have kind of the authority of an intermediator representing it on their behalf, and someone with the authority of both RDRV and VCAT, and that, I think, is arguably the most powerful part of the model in contributing to that equalisation.
Yeah, that's really helpful to hear about. I guess I wondered in a kind of a related way. I mean, what are the sorts of circumstances in which people are using legal advice in connection with disputes, under the kind of the new model? I mean, where and when in the process might that still happen, or might there be an opportunity for people who want legal advice to be able to seek it?
Yeah, there's certainly opportunities throughout, and sometimes the staff will refer people to possible sources of legal assistance and advice where they recognise that they would benefit from that, and that might be owing to complexity or vulnerability in the given circumstances. But actually, Jack, you might be able to sort of add something a bit more to that in terms of some of the specific cases that you see or that your team deals with.
Yeah, I think the legal advice part of it is that we encourage that at every point. Like, I think that if people need that support and want that support, then that's definitely things we provide the resource to. I think there's no sort of hard and fast timeline in terms of that. So I think, one thing, even if a matter is still waiting for a hearing and we've gone through our process of it, there are still matters that people will you'll get an email and we'll still pick up and try and help with. So it's not a hard and fast or a cut-off matter. But I think very commonly what we will see is that people will want advice for the consent agreements that Warwick sort of mentioned, that people will get to that point and then want to get a second opinion on that. And that's totally fine. And we would encourage people to do so. I think if you are entering into an agreement, you need to make sure that you're comfortable with what you are doing. And so, we can provide that comfort from our point of view, but if that legal advice isn't something that we can sort of go into detail on, so we would always sort of endorse that and push that on for sure.
Right. And I wonder, I mean, in terms of the early evidence, I mean, because we're still relatively early in the sort of the existence of this particular approach with RDRV, but could you tell us a bit about what the early evidence suggests about what's being achieved, and whether anything in the findings has surprised you about what's been happening so far?
Yeah, I mean, it's still, as you say, kind of fairly early, but in some ways, we have been engaged in this for quite some time, even before the official go live in June last year. And so we are forming, a reasonably good picture of a number of different things. I guess there's a few things. I mean, we have consistently maintained quite high early resolution rates. So, it's been possible for us to resolve quite a number of the matters that RDRV deals with without needing to go through to a formal hearing. And while it may take, even more time to sort of completely even out over the span of time, it's always been sort of in that roughly more than 50%, between 50 and 60% kind of resolution of matters, of applications that are brought to us. So in some ways, I think that's surprising because, mediation services in general don't, anything around 50% is considered a very high, resolution rate for a conciliation or mediation service. And it probably speaks to, to some extent, the lack of certainty that many parties have before they make applications about the need for an application and whether or not they can be better helped through having high quality information. I think, there's a couple of other sort of things that probably did surprise us. One of them was the extent to which there has been real willingness to engage with the model. I think at times we questioned whether or not people would want to participate in this process, and it has always been a voluntary process. And we had some concerns that property managers in particular may not be able to recover fees under their contractual arrangements, for example, and might therefore think, well, actually, there's a commercial barrier to participation in the process. But actually, we've sort of seen almost the opposite. Like there's been a high degree of enthusiasm for the model and a sort of recognition of the value that it can add to the work of property managers, as well as the experience of renters. So it's not really been an issue for us to try to elicit kind of more engagement with the model. Also, I think we've probably experienced more success with urgent repairs and repairs-related matters more generally than we might have thought, because I think Jack mentioned earlier that there is a sort of statutory requirement around having those matters brought to hearing, and so we've had to really prioritise those from a timing standpoint. But equally, it's probably and largely been able to do that fairly effectively. But it's probably revealed that in some ways the key thing that was needed in that area was not so much sort of an expedited kind of hearing and a determinative outcome, but actually some brokering of the discussions between parties. And I'm talking here also about the relationship between property managers and rental providers, as opposed to property managers and renters. So often there will be sort of circumstances where a property manager might say, I've been wanting these repairs to get done, but I'm just having difficulty securing the necessary, endorsement of the rental provider, and just our involvement can be enough to unblock that sometimes. So you know, we have probably seen some, you know, benefits in areas that we thought might be actually the model may not be as well suited to, which has been, you know, quite pleasing in a lot of ways. In terms of just the overall sort of numbers, I think we're sort of seeing that we've had gradually more demand over time is sort of starting to build up, and probably more phone calls than we had really anticipated. So these are even sort of just calls where people have not necessarily decided to make an application, but we've dealt with, I think, in the order of 40,000 phone calls since June last year. And you know, that number just seems to be kind of growing quite a lot. So there's a real thirst for information. I think that's probably pretty evident, and the thirst for you know, people to be able to speak to someone about how to resolve a dispute. So yeah, we're still you know, working on reducing the amount of time spent in between application and finalisation. And when we have kind of established the baseline for that, I think we'll have, you know, even more insight into you know, the experience of people in the system and what benefits the model can be applied to.
Right. I mean, I wonder just on that question of the evidence and, you know, people's experiences, what are the sorts of approaches you're using to gather feedback from people who've used RDRV, and how might that feedback sort of play a part in how the service evolves over time?
Yeah, it's again, it's a fairly big part of the model. We don't actually have a formal sort of survey based model, though it's very much on the agenda to get direct kind of feedback from users in the form of, you know, online surveys and things like that. What we are sort of able to get quite readily at the moment is insight directly from the resolution coordinators, who are, as I say, kind of having day-to-day conversations with the users, and from a group of intake officers, we call them as well, who answer phones in particular, and then also working with organisations that represent our user group. So in the case of property managers, that might be the Real Estate Institute, and there are other groups that do likewise sort of represent property managers. And then for renters, commonly that's in the legal services, so the groups like Tenants Victoria and Aboriginal Legal Services, and then we also regularly speak with Legal Aid and other CLCs. So we're getting quite a lot of feedback, and we've run a number of different types of stakeholder engagement with those groups collectively and individually, including regular kind of roundtable conversations. And so, you know, the process of getting feedback has been quite extensive, and it's something we've known right from the start we would need to do, because we had to create the service in such a sort of short space of time. So the time between, you know, the announcement about RDRV coming to VCAT and then it going live was really only a matter of you know, probably less than 9 months in the end. And so, you know, we knew that it was going to be critical to be able to have kind of effective feedback mechanisms in place that would allow us to make changes, you know, quite readily and adapt. And, you know, at a large scale, we've done that, you know, in the form of things like changes to our technology platform. So, you know, we had to deploy quite a new technology platform and way of engaging with the system. It was unlike anything we had really done before, through the use of an online portal, other than in our civil claims area. And, you know, we had strong feedback, particularly from the property sector, that that model didn't really work in a firm-based environment. And so we've had to rapidly respond to that through creation of, you know, a business level account for that portal, which is, you know, sounds in some ways simple, but it actually been extremely complex in practice to build. So that sort of thing. But even at a relatively low level as well, we've made quite small adjustments to the model that have made kind of fairly significant differences. So we're getting, as an example, quite a lot of feedback from resolution coordinators. So when I was talking with parties, and particularly perhaps with renters, when they were talking about going into negotiation with you know, the other party involved, that word negotiation was actually just generating a degree of discomfort and you know, unsettledness. And so they started, we just made a sort of a general change to the sort of operating procedures for the resolution coordinators to replace the word negotiation with discussion, which essentially, means largely the same thing, but it was just enough to sort of take some of the concern out of those early conversations, and people felt a little bit more free to, engage in the conversation without thinking that, that they were being potentially going to be held to a particular outcome. So, and it really kind of did emphasise those points that particularly Jack was making earlier about the party being kind of in control of the process. So just things like that, kind of just we're just constantly working through, conducting kind of internal listening sessions so we can make adjustments to the model, making adjustments to, some of the information collateral that we use and application forms and things like that as well.
Great. We've got our last few questions before we'll have time for some Q&A. So I think there's been a note in the chat, but if anyone's got a question, you're welcome to post it in the Q&A for a part that we'll get to in just a moment. Last couple of questions. So I mean, for someone who came to this session today, or was feeling generally daunted by the prospect of a tenancy dispute, I mean, what's the single biggest takeaway you'd like someone in that position to sort of have about approaching RDRV for assistance with resolving their dispute at this point?
Yeah, Jack, I might throw to you on that one. I think actually, because you deal with people so regularly.
Yeah, well, it's interesting, that question, because it almost sounds like the answer is like, if you say the single thing I would say to someone in that position, is one of the most common bits of feedback I get from parties is that the process was so much less, it wasn't daunting at all. So I think people do have this perception that, I mean, going to court, tribunal, those sort of things, it is a stressful thing. No one wants to be here, right? And then usually a case, not only that, it's usually, there's been a lot of sort of build up and a lot of things that have happened to lead to a point that an application has gone in. And then from a tenant perspective, there's a lot of stress out there around, oh, well, is this going to leave a black mark on my name? Or is this going to ruin it for this? All I want to do is get mold taken off my wall, which is such a common and such a no one should have black mold on their walls. But I think that through a lot of what we do as resolution coordinators, a lot of what we want to embed and get people understanding is the why behind things. So not only doing things, but explaining why and how this plays into it. And I think understanding the why, the process, is so key into just getting a little bit more comfort around these things that are really out of your control. So a lot of what we try to do is give people some of that control back in terms of letting them know what's going on, what options they have. But yeah, I think it is the easily, hands down, not even close, the single most common bit of feedback I've gotten, and that includes both negative and positive from parties, is that this process was a lot more easy and relaxed than they thought. So and it's also completely voluntary. So I think some people don't realize that when they come in, you don't want to go into mediation with someone. That's fine. We have other options that we can look at. And sometimes if you want it to just go straight to a hearing, totally fine. We can facilitate that and do that as quickly as possible as well. So there's a lot more control and autonomy with the people coming through than I think they ever realize as well.
Right. And then finally, I mean, looking ahead, without holding you to specific performance metrics, I mean, what would a successful performance look like for RDRV in 5 years? If we were sort of to cast ahead, what would you be hoping for?
Yeah, it's a good question, because I think, I mean, one thing when you're working dispute resolution is that in some ways your ideal is to not have a job at the end, because really, it would be ideal if we could just avoid these things. And it's not totally kind of glib either. I think there's, we're very aware that we're operating in an environment that's the subject of a lot of legislative interest, and that there's significant changes being made all the time to the rental sector and the rental legislative environment that will have a significant bearing on the way we do things. But equally, I think there's also a lot of changes to the information environment, and that is actually really crucial for our work, because the more information that people can, access readily, even without the involvement of, a service like RDRV or any of the other services, arguably the less need there will be for a formal application or involvement in dispute resolution. So, in some ways that would be part of the sort of 5-year model, is that we'd actually probably like to see more cases diverted even before they get to a stage where there's some requirement to commence. I think everyone acknowledges that at least initially there's probably a lot of untapped need, and so when we see that there's quite a lot of demand for the service, that's probably some indication that it's having a positive impact. So I think, look, in 5 years, it would probably be echoing a lot of the things that Jack was just talking about. Like, I think there'd probably be around those key themes of confidence and clarity and proportionality. So, wanting to be sure that that people, when they access the service, have a degree of confidence around the steps that they've taken. They feel that it's the right thing to have done in their circumstances, and importantly, that it gives them the sort of a durable platform from which to sort of go forward. So they won't be sort of locked into further dispute in particular, but equally that they have what they require in order to be able to sort of move on with their lives. And then proportionally, I think it's really about making sure that the amount of time spent in the service is reasonable and proportionate to the case. And obviously the time's always a bit of a balancing act. We have to, obviously ideally reduce the amount of time in matters, but equally we don't want to create a sense of pressure around time. And to some extent, people's ability to participate in the process needs to be allowed to unfold to some degree. But it should be there should be a sense that it's proportionate, and that that they haven't spent undue amount of time just waiting for something to resolve that has kind of prevented them from being able to take other steps in their lives. And equally, I think the amount of kind of emotional investment should be reasonably as low as it can be, and therefore proportion as well. It's never going to be completely eliminated, of course, but the extent to which things like confusion and distress and other things can be reduced by a service like this, that's really a critical measure for its long-term success. And so these are the sorts of things we'll start to increasingly to measure as part of our kind of sentiment surveys and things as well. So I think it'll probably be around those kind of core themes that will be looking for evidence of the benefits of the model in future.
Terrific. And Jack, did you want to add anything further in respect of that idea around success?
No, I think it's like, for me, that's for what Warwick's touched on is pretty much covered it. I think is learning from what we do and just refining and getting better as a response. So we are pretty much in our infancy. So I think that it's something that RDRV does really, really well in terms of seeing things and seeing those subtle tweaks to what Warwick mentioned earlier. But yeah, I think just a continuation of that will put us in really good stead.
Right. All right. Terrific. Well, thanks very much for that. We have some questions in the Q&A window. There's a few of them there, so I might just pick a few of them out to deal with. One of the questions that's been asked is, when there's so much flexibility, how do you make sure things are fair? That tension between balancing people's rights and solving the problem quickly. Yeah, is that something you'd like to address, Jack?
Yeah, I think being very consultative is a very key part of that, right? So if we're looking at a fairness or a fair outcome, I think one important thing to understand is what's fair to someone might not be fair to someone else. What's fair legally could also be slightly different to what's fair or the priority for that particular person. So a lot of what we would do is to understand the parties that we're dealing with, and if there is sort of any sort of indication of any sort of power imbalance or not fair, that sort of starts to fall in the bracket of, well, maybe this is something that needs to be handled by a member and actually get that specific advice on. So we don't have that legal background to make that determination. We would only come up with an outcome if it's been driven and is sort of a natural fruition of the two parties coming together and something that was in their best interests. But we don't want to be in a position where it's sort of flirting with that. We don't want to drive an outcome for the sake of driving an outcome. I think we're very much, all on the same page that the outcome is what suits the people involved, not a particular predetermined thing that we're aiming for.
Thanks for that. And there's another question here about enforcement of orders and agreements, and the whether or how you might track those, and if you do, what you see in terms of patterns in the data, and how you know whether the agreements that are made actually come to pass. This is a thorny question for civil justice systems more broadly.
Yeah. It is, and unfortunately, there's not much I can say about that from a sort of quantitative standpoint at the moment. And part of the challenge we have at VCAT more widely, not just in RDRV, is that we're not really, we're not empowered to enforce our own orders, but it is possible for people to seek enforcement of our orders through another jurisdiction. So most commonly, in this case, it would be in the magistrate's court. But we at the moment we don't yet have, and we will be getting, I think, more insight into what the enforcement model looks like. I think probably the only evidence we then have around that is probably more anecdotal. And Jack, I'm not sure if you have sort of more specific insight into, when we sort of see people say, come back to us and say that something has not sort of stuck in the long term. But I mean, as a general observation, I'd say, our hope is obviously that we do get more enduring and agreements, and ones that people are more likely to comply with because they have, actually participated in designing them.
I think the thing I would add to that is it is something that we do deal with, is that people come back for whatever reason an order hasn't been carried out. That is a continuation of sort of the why and the communication that I'm talking about. That I think that for our point of view, like I literally had someone in my team on Thursday with this exact issue, and the response is, well, we can't enforce them. It has to go to the magistrate's court. But at the same time, if we can have an additional conversation to both parties at that point about what the possible ramifications are, what the next steps potentially could be, then sometimes that context is enough to actually facilitate an outcome. And I've had quite a few situations like that. And it's sort of a continuation of the communication breakdown, because I would say almost like 80% of the situations where I've dealt with and things like that, the person who's chasing up the order that hasn't been enforced hasn't liaised with that person who hasn't carried it out, because that degraded relationships. So, they'll come back to us, we'll sort of bridge that gap, and sometimes even set up something in a month's time to make sure it's being done. But that we don't have a lot of authority in that respect. So what we can really do is paint the picture and just try and expedite that. But it is more of a last roll of the dice, because once someone doesn't, pay or doesn't do whatever the order says, realistically, going through the process and going through that other thing for enforcement is a process as well. So we're conscious that it will take some time. So we do what we can within the window that we have.
Thanks for that. And Taylor has a fairly specific question here about the relationship between the disputes you're dealing with and family violence. So the question is there a plan to move family violence related proceedings out of RDRV, and a reference to particular applications, 91V applications that are currently properly before VCAT and not an RDRV matter. But yeah, some further specific parameters there, and some concerns around the family violence dimension. Is there something you'd like to say about the way that that those matters are being dealt with through the RDRV process?
Yeah, I'm not sure. Unfortunately, I'm not an expert on the Act, so I can't comment on those specific application types. Although I would say that in general, family violence specific applications are not really dealt with by, so for example, kind of getting someone taken off a lease and things like that would not be dealt with under RDRV. But where there is, it's still quite common for cases that come to RDRV to have family violence as a feature of the underlying kind of case dynamics. And we do have an internal referral model for those cases into our family violence specialist support team. And equally, the resolution coordinators have been given some specific training in relation to family violence. So it's an area of considerable kind of focus. But we can certainly take on notice any specific questions if there were some about some specific types. Yeah.
Sure, and I'm conscious of the time, so I'm going to try and squeeze in a couple more. We have a question from Jackie, who's a lawyer in a CLC, and she says we have a lot of clients who are not able to write or read English. Do you provide interpreters for questions and the proceedings more generally?
Yeah, yes, we do. Yeah. Sorry, good, Jack. Go on.
Oh no, sorry, Warwick. I was saying we definitely do, and it's something that we also encourage a lot of people to seek that, because I think we do get a lot of people with English as a second language who can communicate fine in a conversation, but sometimes understanding some legal interpretations or those things might be another level above. So it's something that we do definitely want to be very proactive with offering people, even if it's something that they are communicating quite well, because we just want to make sure that people understand exactly what's going on. And if anyone who speaks English as a second language, for anyone who's learned another language, you realize how crazy the English language is to learn. So there's a lot of nuances of that. So we want to make sure that people are understanding it for sure.
And our website information is also available in other languages.
Yeah, and for this sort of other impairment things, we do have a disability support team as well, who we engage quite regularly, and they do help with a range of sort of things in hearing preparation, not just for the hearing itself, and gathering documents, part of the process, and they'll go through and assist people throughout the process as well.
Great. We might finish off with a question about black mold, because why not? That's really important. And there's a question here from Sharon, who asks, if a tenant needs black mold removed, what's the likely urgent turnaround for that to be organised through this particular process?
I can say that that's probably, like, from my time as a resolution coordinator and repair applications I did quite a lot of, incredibly common, and probably one of the most satisfying things to deal with as a resolution coordinator, because you can very commonly expedite an outcome with what we were sort of touching on earlier, our involvement. So there are things that you have to have raised it with the property owner and given them an opportunity to come through, but black mold falls under the urgent. There's specific wording under there. I think as long as it's related to the building structure and the premises as a direct cause, then it is considered an urgent repair. And from picking up the application, we would have 2 days to see if we can facilitate getting someone in to do that. If not, it would progress straight to a hearing within that short time frame. So one of the quickest turnarounds we have in terms of application to hearing would be that particular process.
Right. Well, I'm conscious of the time, so thank you very much to Warwick and Jack for joining us. It was really terrific to hear about how the service is functioning and what the experience has been to date. And I'm really interested in hearing more as the evidence base builds. And thanks also to everyone attending and to the Victoria Law Foundation for Law Week. It's a terrific opportunity to hear about these sorts of services and law in Victoria more broadly. So thanks everyone, and have a great day.